aspects. We will continue our discussion with session 2. So I will give the floor to the moderator of the session, Eva Orosz. Thank you very much.
Good morning to everybody. I'm Eva Orosz, professor at the Faculty of Social Sciences at Eötvös Loránd universities, and on the behalf of the organizer, all universities, Semmelweis University and UNICA, very warm welcome to the session on social and legal aspects of COVID-19. As we all know, the COVID-19 pandemic caused highly disruptive changes in the everyday life, operation, relationship, individuals, institutions, societies, economies, and the government. And the medium and long-term changes seem highly uncertain and unpredictable. All these pose an unprecedented challenges on the impetus for researchers of almost all disciplines to reveal, thematize, and explain unfolding trends, key issues. Such an issue is the challenges and changes in the relationship taken in a broad sense between the citizens and the government. The first two presentations of our session concern some aspects of this issue. The third presentation will discuss the economic aspects of COVID-19. So, our first speaker is Professor Hoffman from the Faculty of Law at Eötvös Loránd University, and the title of his presentation is Administration and Administrative Law in the Time of Corona. So, Professor Hoffman, unfortunately,
You might have a technical problem, so let me check.
Should we continue with the second presentation?
Just give me a second. I will check if okay, we can continue with the next presentation. So if Anna Bettina doesn't mind to come first, then it would be great to be able to continue with her presentation. Thanks.
Okay, so I give the floor to Anna.
I'm here, I'm just so. Well, thank you so much for the kind invitation. I'm talking about the question whether Germany's COVID measures violate the constitution, and I do now try to share the screen. Just a second. Do you see my screen?
Not yet.
Not yet.
But actually, sorry. Also István is here. So
okay.
Sorry, the technical issue has been solved. He had some problem to join the webinar as a panelist. But if he's actually ready, I would continue then according to the program, if you don't mind.
Of course.
Good afternoon. Can you hear me? Or good morning?
Excellently. Thank you.
Perfect. And can you see my screen?
Also.
Okay. So, yes. Sorry for the technical problems. My name is István Hoffman, and I would like to talk about the administration and administrative law in the time of Corona. First of all, I should show that my research were supported by national research grants. First of all, as an introduction, my presentation will be based on a jurisprudential method, but because of the importance of COVID on the socio-economic and legal structures, partially, tangentially, I would use the policy analysis as well. First of all, and as an introductory part, why it's very important to talk about the role of public administration in the field of pandemic and in the field of Corona. For me, that picture is one of the most shocking sign of the significance of administrative law. This picture was taken from the tower of the Siena City Hall, and you can see the Siena Cathedral and its unfinished nave. Siena was one of the largest cities in Europe during the early 14th century, but after the Black Death, when the administration of Siena failed to manage the pandemic, the majority of the population died, and the planned and partly finished cathedral became too large for the city, and you can see that unfinished nave because the former smaller and the cathedral became much more smaller. So public administration and administrative law can help to manage the pandemic situations. After that, I would like to talk about the main issues of my presentation. Because administration and administrative law has links to all part of the life. And of course, therefore, the role of the administrative law is very, very difficult and very, very complex phenomena. It's much more difficult for a 15 minutes presentation. I would like to talk about three main issues in the field of administrative law. The first is the organizational issues, especially the state of emergency and the legal regulation on state of emergency. Secondly, the procedures. And third, the service provision in the field of pandemic and healthcare, and not only healthcare, but every other public services which were impacted by the COVID situation. So therefore, I have three major questions and hypotheses. The first of all, were we prepared as a legal system for worldwide pandemic? The second, the analysis of the legislation, the focus of the legislation, and the relation to the legal regulation and to the health issues. And third, COVID-19 as a cover. So the COVID-19 and the legal background noise and silent reforms which were partly related to the COVID-19. Because jurisprudence is one of the most national sciences, because there are, of course, international organizations and there are the European Union, but the nations, the countries have own legal systems. Therefore, my presentation will be based mainly on the Hungarian law and on the Hungarian legal regulation, with a view of mainly of the European countries, but partly on the United States and Australia as well. So I would like to talk about these three main issues. The first of it, were we prepared? If I would like to answer shortly, it's not a classical point for a lawyer that we are talking shortly, not really. State of emergencies were regulated in every European countries, especially in the constitutional law. Professor Kaiser will talk about the German regulation. In Hungary, the regulation is very detailed on state of emergencies, because in Hungary we have a multi-layer system of state of emergencies, and it's very well and very detailed regulated by our constitutions, by the fundamental law of Hungary. In Hungary, there are different types of state of emergencies, and there is one type of them. It's called it's translated into state of danger in Hungarian veszélyhelyzet. It is regulated by the Article 53 of the fundamental law. Actually, its state of danger is modeled industrial and natural disasters. We have introduced several times this state of dangers. In the last 20 years, 2 or 3 times were introduced that state of danger. especially in natural disaster, for example, mainly floods. So the floods, the great floods of the Danube and the river Tisa, and one time industrial disaster. It's the so-called bauxite disaster in the Trans-Danubian mountains. So we have some practice in that, but it's very interesting. Pandemic is not a constitutional cause in our fundamental law to introduce a state of danger, but there is a so-called an act passed by a qualified majority, the Act on Disaster Recovery, which states that pandemic can be a justification for the introduction of state of danger. In Hungarian regulation, state of danger can be introduced by the government of Hungary. So it's a governmental issue to introduce it, and the government can adopt governmental decrees which are contrary to the Act of Parliaments, but there is a strong limitation of that extraordinary power of the government, that these government decrees are only effective for 15 days. And after the expire of that 15 days, these decrees should be passed by the Parliament of Hungary. So if we look at the Act on Health Affairs, there was and there has been a health crisis, definition of health crisis, but the health crisis, which were actually based on pandemics, were originally, this institution originally focused on the special issues of the healthcare service provision, especially to the finances and to the beds, hospital beds. So it was not modeled for lockdowns, for traveling restrictions, and for closing public schools. So the challenges and responses. In Hungary, during the first wave of the pandemic, we had these regulations. The major problem was the 15 days expire of the government decrees, because the pandemic did not finish after 15 days. And a new regulation should be introduced, but in the Hungarian parliamentary law, 15 days is very, very short time for adopting an act. If an act should be adopted within 15 days, then 80% consent of the parliament is required. And it's very, very hard to organize an 80% majority in the Hungarian parliament. So it was very interesting, because a dysfunctional answer has been adopted to that extraordinary situation after the 15th day of the first pandemic, when the first wave of the pandemic, when the state of danger were introduced. Actually, before adopting a new act on emergency, a normative decision of the national chief medical officer actually closed the whole country and maintained the lockdown. It was constitutionally a very problematic element, because the national chief medical officer has the right to decide individually several restrictions related to the pandemic, but it is an individual decision and not a general decision, which should be executed by all bodies of the executive branch in Hungary. So actually, the chief medical officer adopted an act which was called an individual decision or an individual normative decision. So it was constitutionally not very fair and very problematic, but it was a an answer, so it can be interpreted as a resilience of the legal system, because it's not fair, but it was enough for the 2 days. After the 2 days, the parliament adopted an act on the expansion of special government decrees. As I have mentioned, the emergency government decrees expires after 15 days, but this act permitted to the government to have scope for the whole state of danger. So this 15 days expire was terminated by that act for that COVID-19 pandemic. But these problems, the problems with the state of emergency, and especially this 15 days expire, highlighted and emphasized that the Hungarian constitutional regulation was not modeled after pandemic. Therefore, after the first wave, a new quasi-state of emergency was introduced by the amendment of the Act on Health Affairs. It's called epidemiological emergency. It's not a constitutional state of emergency. The Act on Health Affairs is an act passed by the simple majority of the parliament, but it allows to introduce restrictions in the field of fundamental rights as well. So it allows to the government to close the schools, to close the borders, and to introduce several restrictions in social and economic life. It was a very, very highly debated act because, in one hand, it gives a fast response to the challenges for the government, but actually it is some kind of state of danger without the declaration of state of dangers and without the constitutional guarantees of state of dangers, and it is regulated not by constitutional rules but by a simple act, so-called simple act in Hungary. If we look at the legislation on the COVID-19, in Europe there were major issues. First of all, the simplification of the procedures, partly the e-procedures to reduce the number of the contacts, and secondly, it was clear that the pandemic will cause an economic crisis as well. So it was very, very important for the first wave of the pandemic to manage to handle the economic difficulties. Of course, the healthcare services were under attack during the COVID. We could hear it in the first panel as well. Therefore, it should be introduced temporary regulation for healthcare. And to reduce the contacts in the majority of the European and partly in America and in Australia and in lots of countries, school educational restrictions, actually closing the schools, were introduced. And of course, as I have mentioned, the socio-economic crisis caused by the pandemic should be handled as well, and especially the high number of the unemployed people, and therefore unemployment, social benefits, and the restart of the economies were a very important issue in Europe as well. Because the pandemic wanted very, very fast and very prompt answers, actually the pandemic was an accelerator for the centralization tendencies which could be observed during the last 10 years as well. If we look at Hungary, it should be stated that a very, very large sum of government decrees were introduced during the pandemic. The number of the emergencies government decrees was 153. As a remark, in a normal, so in a peacetime year, the average number of the government decrees are 500 for the whole year. And the first wave of the pandemic from the March till the June, it was for a 3 months, actually 3 months period, more than 153 pandemic government decrees. These measures and these regulations, which were introduced during the first wave of the pandemic, remained after the end of the state of danger after June. There were several temporary regulations. For example, as a as a higher education teacher, I should emphasize that our exam period started in May but ended in July, August, but the state of danger ended in June. Therefore, there were several temporary regulations for schools and for higher and for public education till the end of the school year, so till the end of 31st of August, and in several cases temporary regulations till 31st of December. And as I have mentioned, a new quasi-state of danger were introduced by the Hungarian regulation, the so-called epidemic emergency. This epidemic emergency allowed the majority of the restrictions which were used by the state of danger, so closing schools, the possibility to closing schools, closing borders, and to restrict social, cultural, and other events. The Hungarian registration was very, very wide. You can see on the presentation several topics. First of all, I would like to talk about the transformation of the administrative procedure. Originally, there were several regulations on the reduction of the contacts at the administrative bodies. So e-administration and contactless administration were allowed by the temporary regulation during the first wave of the pandemic, during the state of danger. Secondly, it was very, very interesting. All around Europe, one of the major focus on the transformation of the administrative procedure was the acceleration to the access of welfare benefits. In Hungary, actually, it wasn't simplified, the access to welfare benefits. No significant simplification was introduced during the first wave. It was very, very interesting because it was not affected and not impacted by the regulations. There were very strong simplification tendency during the pandemic, but it was very, very interesting because the authorization of economic activities were simplified. And this regulation, which were originally modeled for the state of danger, were introduced after the end of that emergency. A new act was adopted on the simplification of the authorization. Actually, the number of real authorization where the authorities and the impacted clients have right to examine the economic activity were reduced, and the simple declaration type procedure was introduced. It's very interesting and it's highly debated. If you have questions, I can talk it more detailed, but actually it caused the reduction to the accessibility of the administrative protection of the clients, of the citizens, because the administration have reduced competencies to examine these activities, and the people who are impacted by those activities shall sue at civil courts if they want to protect their rights. It's statistics on the number of job seekers in Hungary. You can see it was a very, very...
Professor Hoffman, sorry for interrupting you. I kindly remind you to the time limit, because we would like to spare time for the discussion also.
Okay,
sorry.
just one major element. Centralization and concentration. As I have mentioned, it was very important in all around the world that the centralization tendencies have been strengthened by the pandemic. In Hungary, it was a very interesting situation because the majority of the Hungarian public services were centralized during the last decade. But the centralization strengthened after the pandemic, but an opposite tendency can be observed. Municipalities and autonomies as trash cans of administrations, because the most unpopular decisions were introduced by the municipalities, and the municipalities were asked to help people. And some municipalities, mainly the urban and maybe mainly the rich municipalities, introduced several welfare benefits which weren't introduced by Hungary. As a closing element, if we look at the major issues in Europe, health crisis and the limitation of the impact of the epidemic was in the focus of the European legislation. And secondly, restart was the second major issue. Hungary partly followed and follows the European pattern. Of course, we have very new regulation, very important regulation on health services and the restart of the economies. But this legislative background noise, this more than 100 government decrees and a lot of acts were, how can I say, a time for reforms. Because in the time of Corona, some reforms, some major reforms were introduced very, very quickly. The last one was the reform of the healthcare 2 days ago. And secondly, the centralization and concentration have been strengthened, especially the financial autonomy of the municipalities have been reduced by several regulations. So, as a closing sentence, the major issue in Hungary was the change of the restart of the economy. You can see why. The Hungarian economy was hit by the pandemic. Actually, the reduction of the GDP was higher than in 2008. Thank you very much, and sorry for my bad time management.
Thank you for the very interesting presentation, and I immediately give the floor to Professor Anna Bettina Kaiser from the Humboldt University.